Part 4. Rules of Evidence. Rule 128. General Provisions. Section 1. Evidence defined. Evidence is the means, sanctioned by these rules, of ascertaining in a judicial proceeding the truth respecting a matter of fact. 1. Section 2. Scope. The rules of evidence shall be the same in all courts and in all trials and hearings, except as otherwise provided by law or these rules. 2a. Section 3. Admissibility of evidence. Evidence is admissible when it is relevant to the issue and is not excluded by the law of these rules. 3a. Section 4. Relevancy, collateral matters. Evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. Evidence on collateral matters shall not be allowed, except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. 4a. Rule 129. What need not be proved. Section 1. Judicial notice, when mandatory. A court shall take judicial notice, without the introduction of evidence, of the existence and territorial extent of states, their political history, forms of government and symbols of nationality, the law of nations, the admiralty and maritime courts of the world and their seals, the political constitution and history of the Philippines, the official acts of legislative, executive, and judicial departments of the Philippines, the laws of nature, the measure of time, and the geographical divisions. 1a. Section 2. Judicial notice, when discretionary. A court may take judicial notice of matters which are of public knowledge, or are capable to unquestionable demonstration, or ought to be known to judges because of their judicial functions. 1a. Section 3. Judicial notice, when hearing necessary. During the trial, the court, on its own initiative, or on request of a party, may announce its intention to take judicial notice of any matter and allow the parties to be heard thereon. After the trial, and before judgment or on appeal, the proper court, on its own initiative or on request of a party, may take judicial notice of any matter and allow the parties to be heard thereon if such matter is decisive of a material issue in the case. N. Section 4. Judicial admissions. An admission, verbal or written, made by the party in the course of the proceedings in the same case, does not require proof. The admission may be contradicted only by showing that it was made through palpable mistake or that no such admission was made. 2a. Rule 130. Rules of admissibility. A. Object, real, evidence. Section 1. Object as evidence. Objects as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined or viewed by the court. 1a. B. Documentary evidence. Section 2. Documentary evidence. Documents as evidence consist of writing or any material containing letters, words, numbers, figures, symbols, or other modes of written expression offered as proof of their contents. N. 1. Best evidence rule. Section 3. Original document must be produced, exceptions. When the subject of inquiry is the contents of a document, no evidence shall be admissible other than the original document itself, except in the following cases. A. When the original has been lost or destroyed, or cannot be produced in court, without bad faith on the part of the offerer. B. When the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time and the fact sought to be established from them is only the general result of the whole, and D. When the original is a public record in the custody of a public officer or is recorded in a public office. 2a. Section 4. Original of document. A. The original of the document is one the contents of which are the subject of inquiry. B. when a document is in 2 or more copies executed at or about the same time, with identical contents, all such copies are equally regarded as originals. c. When an entry is repeated in the regular course of business, one being copied from another at or near the time of the transaction, all the entries are likewise equally regarded as originals. 3a. 2. Secondary evidence. Section 5. When original document is unavailable. When the original document has been lost or destroyed, or cannot be produced in court, the offerer, upon proof of its execution or existence and the cause of its unavailability without bad faith on his part, may prove its contents by a copy, or by a recital of its contents in some authentic document, or by the testimony of witnesses in the order stated. 4a. Section 6. When original document is in adverse party's custody or control. If the document is in the custody or under the control of adverse party, he must have reasonable notice to produce it. If after such notice and after satisfactory proof of its existence, he fails to produce the document, secondary evidence may be presented as in the case of its loss. 5a. Section 7. Evidence admissible when original document is a public record. When the original of document is in the custody of public officer or is recorded in a public office, its contents may be proved by a certified copy issued by the public officer in custody thereof. 2a. Section 8. Party who calls for document not bound to offer it. A party who calls for the production of a document and inspects the same is not obliged to offer it as evidence. 6a. 3. Parole evidence rule. Section 9. Evidence of written agreements. When the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon, and there can be, between the parties and their successors in interest, no evidence of such terms other than the contents of the written agreement. However, a party may present evidence to modify, explain, or add to the terms of written agreement if he puts in issue in his pleading a. An intrinsic ambiguity, mistake, or imperfection in the written agreement. b. The failure of the written agreement to express the true intent and agreement of the parties thereto. c. The validity of the written agreement, or d. The existence of other terms agreed to by the parties or their successors in interest after the execution of the written agreement. The term agreement includes wills. 7a. 4. Interpretation of documents. Section 10. Interpretation of a writing according to its legal meaning. The language of a writing is to be interpreted according to the legal meaning it bears in the place of its execution, unless the parties intended otherwise. 8. Section 11. Instrument construed so as to give effect to all provisions. In the construction of an instrument, where there are several provisions or particulars, such a construction is, if possible, to be adopted as will give effect to all. 9. Section 12. Interpretation according to intention, general and particular provisions. In the construction of an instrument, the intention of the parties is to be pursued, and when a general and a particular provision are inconsistent, the latter is paramount to the former. So a particular intent will control a general one that is inconsistent with it. 10. Section 13. Interpretation according to circumstances. For the proper construction of an instrument, the circumstances under which it was made, including the situation of the subject thereof and of the parties to it, may be shown, so that the judge may be placed in the position of those whose language he is to interpret. 11. Section 14. Peculiar signification of terms. The terms of a writing are presumed to have been used in their primary and general acceptation, but evidence is admissible to show that they have a local, technical, or otherwise peculiar signification, and were so used and understood in the particular instance, in which case the agreement must be construed accordingly. 12. Section 15. Written words control printed. When an instrument consists partly of written words and partly of a printed form, and the two are inconsistent, the former controls the latter. 13. Section 16. experts and interpreters to be used in explaining certain writings. When the characters in which an instrument is written are difficult to be deciphered, or the language is not understood by the court, the evidence of persons skilled in deciphering the characters, or who understand the language, is admissible to declare the characters or the meaning of the language. 14. Section 17. Of two constructions, which preferred. When the terms of an agreement have been intended in a different sense by the different parties to it, that sense is to prevail against either party in which he supposed the other understood it, and when different constructions of a provision are otherwise equally proper, that is to be taken which is the most favorable to the party in whose favor the provision was made. 15. Section 18. Construction in favor of natural right. When an instrument is equally susceptible of two interpretations, one in favor of natural right and the other against it, the former is to be adopted. 16. Section 19. Interpretation according to usage. An instrument may be construed according to usage, in order to determine its true character. 17. C. Testimonial evidence. 1. Qualification of witnesses. Section 20. Witnesses, their qualifications. Except as provided in the next succeeding section, all persons who can perceive, and perceiving, can make their known perception to others, may be witnesses. Religious or political belief, interest in the outcome of the case, or conviction of a crime unless otherwise provided by law, shall not be ground for disqualification. 18a. Section 21. Disqualification by reason of mental incapacity or immaturity. The following persons cannot be witnesses. A. Those whose mental condition, at the time of their production for examination, is such that they are incapable of intelligently making known their perception to others. B. Children whose mental maturity is such as to render them incapable of perceiving the facts respecting which they are examined and of relating them truthfully. 19a. Section 22. Disqualification by reason of marriage. During their marriage, neither the husband nor the wife may testify for or against the other without the consent of the affected spouse, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. 20a. Section 23. Disqualification by reason of death or insanity of adverse party. Parties or assignor of parties to a case, or persons in whose behalf a case is prosecuted, against an executor or administrator or other representative of a deceased person, or against a person of unsound mind, upon a claim or demand against the estate of such deceased person or against such person of unsound mind, cannot testify as to any matter of fact occurring before the death of such deceased person or before such person became of unsound mind. 20a. Section 24. Disqualification by reason of privileged communication. The following persons cannot testify as to matters learned in confidence in the following cases. A. The husband or the wife, during or after the marriage, cannot be examined without the consent of the other as to any communication received in confidence by one from the other during the marriage except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other or the latter's direct descendants or ascendants. B. An attorney cannot, without the consent of his client, be examined as to any communication made by the client to him, or his advice given thereon in the course of, or with a view to, professional employment, nor can an attorney's secretary, stenographer, or clerk be examined, without the consent of the client and his employer, concerning any fact the knowledge of which has been acquired in such capacity. C. A person authorized to practice medicine, surgery, or obstetrics cannot in a civil case, without the consent of the patient, be examined as to any advice or treatment given by him or any information which he may have acquired in attending such patient in a professional capacity, which information was necessary to enable him to act in capacity, and which would blacken the reputation of the patient. D. A minister or priest cannot, without the consent of the person making the confession, be examined as to any confession made to or any advice given by him in his professional character in the course of discipline enjoined by the church to which the minister or priest belongs. E. A public officer cannot be examined during his term of office or afterwards, as to communications made to him in official confidence, when the court finds that the public interest would suffer by the disclosure. 21a. 2. Testimonial privilege. Section 25. Parental and filial privilege. No person may be compelled to testify against his parents, other direct descendants, children, or other direct descendants. 20a. 3. Admissions and confessions. Section 26. Admission of a party. The act, declaration, or omission of a party as to a relevant fact may be given in evidence against him. 22. Section 27. Offer of compromise not admissible. In civil cases, an offer of compromise is not an admission of any liability, and is not admissible in evidence against the offerer. In criminal cases, except those involving quasi-offenses, criminal negligence, or those allowed by law to be compromised, an offer of compromise by the accused may be received in evidence as an implied admission of guilt. A plea of guilty later withdrawn, or an unaccepted offer of a plea of guilty to lesser offense, is not admissible in evidence against the accused who made the plea or offer. An offer to pay or the payment of medical, hospital or other expenses occasioned by an injury is not admissible in evidence as proof of civil or criminal liability for the injury. 24a. Section 28. Admission by third party. The rights of a party cannot be prejudiced by an act, declaration, or omission of another, except as hereinafter provided. 25a. Section 29. Admission by CO partner or agent. The act or declaration of a partner or agent of the party within the scope of his authority and during the existence of the partnership or agency, may be given in evidence against such party after the partnership or agency is shown by evidence other than such act or declaration. The same rule applies to the act or declaration of a joint owner, joint debtor, or other person jointly interested with the party. 26a. Section 30. Admission by conspirator. The act or declaration of a conspirator relating to the conspiracy and during its existence, may be given in evidence against the CO conspirator after the conspiracy is shown by evidence other than such act of declaration. 27. Section 31. Admission by privies. Where one derives title to property from another, the act, declaration, or omission of the latter, while holding the title, in relation to the property, is evidence against the former. 28. Section 32. Admission by silence. An act or declaration made in the presence and within the hearing or observation of a party who does or says nothing when the act or declaration is such as naturally to call for action or comment if not true, and when proper and possible for him to do so, may be given in evidence against him. 23a. Section 33. Confession. The declaration of an accused acknowledging his guilt of the offense charged, or of any offense necessarily included therein, may be given in evidence against him. 29a. 4. Previous conduct as evidence. Section 34. Similar acts as evidence. Evidence that one did or did not do a certain thing at one time is not admissible to prove that he did or did not do the same or similar thing at another time, but it may be received to prove a specific intent or knowledge, identity, plan, system, scheme, habit, custom, or usage, and the like. 48a. Section 35. Unaccepted offer. An offer in writing to pay a particular sum of money or to deliver a written instrument or specific personal property is, if rejected without valid cause, equivalent to the actual production and tender of the money, instrument, or property. 49a. 5. Testimonial knowledge. Section 36. Testimony generally confined to personal knowledge, hearsay excluded. A witness can testify only to those facts which he knows of his personal knowledge, that is, which are derived from his own perception, except as otherwise provided in these rules. 30a. 6. Exceptions to the hearsay rule. Section 37. Dying declaration. The declaration of a dying person, made under the consciousness of an impending death, may be received in any case wherein his death is the subject of inquiry, as evidence of the cause and surrounding circumstances of such death. 31a. Section 38. Declaration against interest. The declaration made by a person deceased, or unable to testify, against the interest of the declarant, if the fact is asserted in the declaration was at the time it was made so far contrary to declarant's own interest, that a reasonable man in his position would not have made the declaration unless he believed it to be true, may be received in evidence against himself or his successors in interest and against third persons. 32a. Section 39. Act or declaration about pedigree. The act or declaration of a person deceased, or unable to testify, in respect to the pedigree of another person related to him by birth or marriage, may be received in evidence where it occurred before the controversy, and the relationship between the two persons is shown by evidence other than such act or declaration. The word pedigree includes relationship, family genealogy, birth, marriage, death, the dates when and the places where these fasts occurred, and the names of the relatives. It embraces also facts of family history intimately connected with pedigree. 33a. Section 40. Family reputation or tradition regarding pedigree. The reputation or tradition existing in a family previous to the controversy, in respect to the pedigree of any one of its members, may be received in evidence if the witness testifying thereon be also a member of the family, either by consanguinity or affinity. Entries in family Bibles or other family books or charts, engravings on rings, family portraits and the like, may be received as evidence of pedigree. 34a. Section 41. Common reputation. Common reputation existing previous to the controversy, respecting facts of public or general interest more than 30 years old, or respecting marriage or moral character, may be given in evidence. Monuments and inscriptions in public places may be received as evidence of common reputation. 35. Section 42. Part of residential gesti. Statements made by a person while a starting occurrence is taking place or immediately prior or subsequent thereto with respect to the circumstances thereof, may be given in evidence as part of residential gesti. So, also, statements accompanying an equivocal act material to the issue, and giving it a legal significance, may be received as part of the residential gesti. 36a. Section 43. Entries in the course of business. Entries made at, or near the time of transactions to which they refer, by a person deceased, or unable to testify, who was in a position to know the facts therein stated, may be received as prima facie evidence, if such person made the entries in his professional capacity or in the performance of duty and in the ordinary or regular course of business or duty. 37a. Section 44. Entries in official records. Entries in official records made in the performance of his duty by a public officer of the Philippines, or by a person in the performance of a duty specially enjoined by law, are prima facie evidence of the facts therein stated. 38. Section 45. Commercial lists and the like. Evidence of statements of matters of interest to persons engaged in an occupation contained in a list, register, periodical, or other published compilation is admissible as tending to prove the truth of any relevant matter so stated if that compilation is published for use by persons engaged in that occupation and is generally used and relied upon by them therein. 39. Section 46. Learned treatises. A published treatise, periodical, or pamphlet on a subject of history, law, science, or art is admissible as tending to prove the truth of a matter stated therein if the court takes judicial notice, or a witness expert in the subject testifies, that the writer of the statement in the treatise, periodical, or pamphlet is recognized in his profession or calling as expert in the subject. 40a. Section 47. Testimony or deposition at a former proceeding. The testimony or deposition of a witness deceased or unable to testify, given in a former case or proceeding, judicial or administrative, involving the same parties and subject matter, may be given in evidence against the adverse party who had the opportunity to cross-examine him. 41a. 7. Opinion Rule. Section 48. General Rule. The opinion of witness is not admissible, except as indicated in the following sections. 42. Section 49. Opinion of expert witness. The opinion of a witness on a matter requiring special knowledge, skill, experience, or training which he shown to possess, may be received in evidence. 43a. Section 50. Opinion of ordinary witnesses. The opinion of a witness for which proper basis is given, may be received in evidence regarding a. The identity of a person about whom he has adequate knowledge. b. A handwriting with which he has sufficient familiarity, and c. The mental sanity of a person with whom he is sufficiently acquainted. The witness may also testify on his impressions of the emotion, behavior, condition, or appearance of a person. 44a. 8. Character evidence. Section 51. Character evidence not generally admissible, exceptions. a. In criminal cases. 1. The accused may prove his good moral character which is pertinent to the moral trait involved in the offense charged. 2. Unless in rebuttal, the prosecution may not prove his bad moral character which is pertinent to the moral trait involved in the offense charged. 3. The good or bad moral character of the offended party may be proved if it tends to establish in any reasonable degree the probability or improbability of the offense charged. b. In civil cases. Evidence of the moral character of a party in civil case is admissible only when pertinent to the issue of character involved in the case. c. In the case provided for in Rule 132, Section 14, 46a, 47a. Rule 131. Burden of proof and presumptions. Section 1. Burden of proof. Burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish his claim or defense by the amount of evidence required by law. 1a, 2a. Section 2. Conclusive presumptions. The following are instances of conclusive presumptions. a. Whenever a party has, by his own declaration, act, or omission, intentionally and deliberately led to another to believe a particular thing true, and to act upon such belief, he cannot, in any litigation arising out of such declaration, act, or omission, be permitted to falsify it. b. The tenant is not permitted to deny the title of his landlord at the time of commencement of the relation of landlord and tenant between them. 3a. Section 3. Disputable presumptions. The following presumptions are satisfactory if uncontradicted, but may be contradicted and overcome by other evidence. a. That a person is innocent of crime or wrong. b. That an unlawful act was done with an unlawful intent. c. That a person intends the ordinary consequences of his voluntary act. d. That a person takes ordinary care of his concerns. e. That evidence willfully suppressed would be adverse if produced. f. That money paid by one to another was due to the latter. g. That a thing delivered by one to another belonged to the latter. h. That an obligation delivered up to the debtor has been paid. I. That prior rents or installments had been paid when a receipt for the later one is produced. j. That a person found in possession of a thing taken in the doing of a recent wrongful act is the taker and the doer of the whole act, otherwise, that things which a person possess, or exercises acts of ownership over, are owned by him. k. That a person in possession of an order on himself for the payment of the money, or the delivery of anything, has paid the money or delivered the thing accordingly. l. That a person acting in a public office was regularly appointed or elected to it. m. That official duty has been regularly performed. n. That a court, or judge acting as such, whether in the Philippines or elsewhere, was acting in the lawful exercise of jurisdiction. O. That all the matters within an issue raised in a case were laid before the court and passed upon by it, and in like manner that all matters within an issue raised in a dispute submitted for arbitration were laid before the arbitrators and passed upon by them. P. That private transactions have been fair and regular. Q. That the ordinary course of business has been followed. R. That there was a sufficient consideration for a contract. S. That a negotiable instrument was given or endorsed for a sufficient consideration. T. That an endorsement of negotiable instrument was made before the instrument was overdue and at the place where the instrument is dated. U. That a writing is truly dated. V. That a letter duly directed and mailed was received in the regular course of the mail. W. That after an absence of 7 years, it being unknown whether or not the absentee still lives, he is considered dead for all purposes, except for those of succession. The absentee shall not be considered dead for the purpose of opening his succession till after an absence of 10 years. If he disappeared after the age of 75 years, an absence of 5 years shall be sufficient in order that his succession may be opened. The following shall be considered dead for all purposes including the division of the estate among the heirs. 1. A person on board a vessel lost during a sea voyage, or an aircraft with is missing, who has not been heard of for 4 years since the loss of the vessel or aircraft. 2. A member of the armed forces who has taken part in armed hostilities, and has been missing for 4 years. 3. A person who has been in danger of death under other circumstances and whose existence has not been known for 4 years. 4. If a married person has been absent for 4 consecutive years, the spouse present may contract a subsequent marriage if he or she has well-founded belief that the absent spouse is already dead. In case of disappearance, where there is a danger of death the circumstances hereinabove provided, an absence of only 2 years shall be sufficient for the purpose of contracting a subsequent marriage. However, in any case, before marrying again, the spouse present must institute a summary proceedings as provided in the Family Code and in the rules for declaration of presumptive death of the absentee, without prejudice to the effect of reappearance of the absent spouse. X. That acquiescence resulted from a belief that the thing acquiesced in was conformable to the law or fact. Y. That things have happened according to the ordinary course of nature and ordinary nature habits of life. Z. That persons acting as copartners have entered into a contract of copartnership. A. That a man and woman deporting themselves as husband and wife have entered into a lawful contract of marriage. B. That property acquired by a man and a woman who are capacitated to marry each other and who live exclusively with each other as husband and wife without the benefit of marriage or under void marriage, has been obtained by their joint efforts, work, or industry. C. That in cases of cohabitation by a man and a woman who are not capacitated to marry each other and who have acquired properly through their actual joint contribution of money, property, or industry, such contributions and their corresponding shares including joint deposits of money and evidences of credit are equal. D. That if the marriage is terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, these rules shall govern in the absence of proof to the contrary. 1. A child born before 180 days after the solemnization of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within the 300 days after the termination of the former marriage. 2. A child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within the 300 days after the termination of the former marriage. E. That a thing once proved to exist continues as long as is usual with things of the nature. F. That the law has been obeyed. G. That a printed or published book, purporting to be printed or published by public authority, was so printed or published. H. That a printed or published book, purporting contain reports of cases adjudged in tribunals of the country where the book is published, contains correct reports of such cases. 2. that a trustee or other person whose duty it was to convey real property to a particular person has actually conveyed it to him when such presumption is necessary to perfect the title of such person or his successor in interest. Jj. That except for purposes of succession, when two persons perish in the same calamity, such as wreck, battle, or conflagration, and it is not shown who died first, and there are no particular circumstances from which it can be inferred, the survivorship is determined from the probabilities resulting from the strength and the age of the sexes, according to the following rules. 1. If both were under the age of 15 years, the older is deemed to have survived. 2. If both were above the age 60, the younger is deemed to have survived. 3. If one is under 15 and the other above 60, the former is deemed to have survived. 4. If both be over 15 and under 60, and the sex be different, the male is deemed to have survived, if the sex be the same, the older. 5. If one be under 15 or over 60, and the other between those ages, the latter is deemed to have survived. Kk. That if there is a doubt, as between two or more persons who are called to succeed each other, as to which of them died first, whoever alleges the death of one prior to the other, shall prove the same. In the absence of proof, they shall be considered to have died at the same time. 5a. Section 4. No presumption of legitimacy or illegitimacy. There is no presumption of legitimacy of a child born after 300 days following the dissolution of the marriage or the separation of the spouses. Whoever alleges the legitimacy or illegitimacy of such child must prove his allegation.